questions and make sure that we end on time so I can eat before I teach at 1:10. So I'm Michelle Oberman. I'm the advisor to the Healthcare Law Society, and it's such a pleasure to be able to introduce my colleague, Brad Joondeph. Before I do so, though, I want to thank both the ACS and the Healthcare Law Society for their work in putting the program together today. And I want to encourage those of you who are 1Ls or even 2Ls feeling like maybe you want to get connected to some of the exciting things happening in healthcare law or in the ACS, which I know a little bit less about, to either connect up with Eric at the ACS or with Chaya and Mike, who are the co-presidents of the Healthcare Law Society, because they're doing great things. So many of you already know Brad, and he needs no introduction, but for those of you who don't, my colleague Brad Joondeph teaches constitutional law, federal income tax, and a Supreme Court seminar here at the school. He also is the advisor to the Law Review and to SALSA. Since 2010, he's maintained an extraordinarily useful blog tracking the affordable health care litigation process, and he has the most comprehensive knowledge of the different suits and how they fit together and the different issues, and probably a better purchase on the court's likely way of handling the case than anybody in the country at this point, although nobody really knows. Some of the evidence of it is that
I was just going to say, I think there's one person I know what's happening.
So Brad's work and his opinions have been featured broadly throughout the popular press in ways that really do guide to law professors who worry about how irrelevant their scholarship is. He was recently featured in an editorial and op-ed piece on CNN.com, on the SCOTUS blog. He's been quoted by the USA Today and the New York Times. So he's pretty fabulous as a teacher and as a colleague, and I'm really happy that he's here to talk to us today.
Extremely kind introduction. Thank you so much. Thanks to Chaya and to Eric for inviting me to participate. Eric, by the way, deserves some of the credit for the blog. Eric was on the ground when we started it back in 2010, and I remember distinctly being on vacation in Chicago and trying to be on the phone on my cell phone from, I think it was the Shed Aquarium in Chicago, with my son, pointing out various jellyfish, and I'm trying to converse with Eric, who's reading to me the very first important judicial opinion in all of this, which was the denial of a dismissal motion by the United States by Judge Henry Hudson in the Eastern District of Virginia. This is, it's a topic that we could spend a semester or more on. And what I would like to do is talk about something that I haven't really had the opportunity to express before in a forum like this, which is why I think this is so important. It's hard to know when you're living through history when events are really significant, and there's still remains a distinct possibility that all of this will not be that important. If, for instance, the Supreme Court ends up kicking this case on rather narrow grounds or even jurisdictional grounds, this might all have been really not much at all, a non-event. But it has all the makings of being one of the most important, if not the most important, constitutional issue that's been resolved by the Supreme Court during our lifetime. And I want to just explain why I think that is and why what is going on is so important to pay attention to as law students, as law professors, as people, as citizens interested in our constitutional system. From there, I want to just open it up to answer questions that you all have, maybe more nitty-gritty specific questions about the legal issues, or whatever you want to talk about, because there is so much here that is worth talking about. So, why is this, I think, really important? I think first, what's at issue in the cases that were argued at the Supreme Court is, I think pretty clearly, the most important federal statute that's been enacted in the last 50 years, at least since the Voting Rights Act of 1965. The healthcare system constitutes 17.8% of gross domestic product now, and is on target because health inflation increases at a greater rate than inflation generally is going up. And we are on pace to be at about 20% of GDP in the not too distant future. It is an enormously important thing economically. It is also, you could say, enormously important in non-economic ways, in terms of maybe not a constitutional right, but in terms of civil rights or human rights. The degree to which health care is available in this country to every human being who resides here is a very important thing. And we may strongly disagree about the role of government in doing something about that, but nonetheless, the basic access to health care is an extremely important thing. And 50 million Americans now lack insurance, the basic means that most of us have to accessing the healthcare system. And the costs of a significant health event are likely to send any one of us who is uninsured into bankruptcy. That's a humongous public policy issue. And the Affordable Care Act attempts in a comprehensive way to deal with this problem. Again, I think as a matter of policy, it can be strongly criticized. You could say that the Affordable Care Act is neither fish nor fowl. It does not go all the way of guaranteeing universal access to health care. It's not a single-payer system. It doesn't expand Medicare to all individuals, but builds on the existing private system. It expands Medicaid. It does a variety of things. It still leaves about 16 to 20 million people uninsured, even if it works out as planned. But it nonetheless makes significant inroads on what is really a pressing national problem, regardless of what we think the solution is. So, number one, I think this is a hugely important statute in and of itself. So regardless of what the constitutional question would be, whether this statute survives is really important. Two, if you like politics, this is a hugely intense, ideological, partisan battle that involved all sorts of extraordinary parliamentary maneuvers and shenanigans in order to get it enacted, has continued to define political races subsequently, is going to define the presidential race in 2012, and I'm sure is going to shape elections thereafter. So if you care about politics, boy, I mean, what has politics been in this country? I mean, there's been a fair amount of other issues, but it has been the central sort of political, ideological issue of the last 4 years. Three, the constitutional question. The constitutional questions on top of this, right? Completely aside from the politics, completely aside from the policy questions, the constitutional issues could not be more fundamental. Could not be more fundamental. This is what they were debating in Philadelphia in 1787. What is the role of the national government, and what is going to be left to the states, right? Whether the federal government has the authority within its regulatory powers to require every individual to purchase health insurance beginning, or an applicable individual beginning in January of 2014, goes to the heart of what we've been debating all the way back to 1787, and you could trace it back even before then, when they were trying to figure out what's wrong with the Articles of Confederation, right? It was debated at length in the 1830s, when South Carolina is threatening to secede over the tariff crisis. And in 1850, when we get the Compromise of 1850. In 1860 and 1861, and that little disagreement we had in the country for 4 years, right, was about the breadth and power of the national government and the power of the states relative thereto. And it became an issue during the New Deal. And it became an issue during the Civil Rights Movement, right? You go back and look at the contemporary defenses of what the states were doing with respect to segregation, they were dressed up in defenses of the national government, the Supreme Court of the United States, invading the sphere and autonomy of the states. right, in a realm that they thought was their own. So this is an issue that we have confronted constitutionally since our beginning, and it goes to the very heart of what our system creates architecturally. What authority is there for the federal government? What is left to the exclusive domain of the state? What is the size of this national government that we will have? What are the breadths of its powers? What are the sorts of circumstances that authorize the extraordinary use of federal power, you could say, that are included in a federal mandate to purchase a commercial product? And you could say it's just as significant with respect to the spending power. Because the spending power issue, the second issue in the case about the expansion of Medicaid, right, underwrites a lot of the modern welfare state. Social Security, Medicare, all sorts of stuff. What, 12% roughly of the budget for primary education in the United States is provided by the federal government to school districts under Chapter 1, Title I funding. So an enormous amount of existing government is underwritten by federal grant in aid to the states, all of which have certain conditions attached. That's precisely what's being debated. The breadth of that authority is precisely what's being debated in the Medicaid expansion part of the case. Lastly, and to me actually what is most interesting as a scholar, though I don't think it should be most interesting to necessarily to all of you or to citizens generally, what a window into how courts actually work and how judges actually make decisions. I think the court, as I've tried to express, I think somewhat uneloquently in various places, I think this case puts the court in a position to have to really define and come to terms with what its role is exactly. Because, I mean, given everything that's going on here, the importance of the issues, the partisan and ideological and deeply divisive nature of the controversy, the importance, the sheer importance of the statute, put the court in the position of deciding, right, is it for us to decide for the 300 million of us? Is it for basically, I mean, let's be frank, is it for 5 of us to decide for the remaining 300 million that this statute's going to go down? Or is it, and is that a perfectly legitimate exercise of the judicial power? Because that's precisely the role the court is supposed to play, right? To make sure that the boundaries, the basic boundaries of our system are policed, and that the political process will never police itself entirely. We need to have the court to prevent the excess aggregation of power that Congress will always give to itself. Right? Is that what the court should do? Is that what its warrant is to do, going all the way back to Marbury versus Madison? Or instead, is this a circumstance where the court should say, look, you know, politics seem to be sorting through this. There is not a discrete and insular minority that's unable to voice itself in the political process. There are other ways in which this problem can be solved, through elections, through politics. It's better for us to step aside in some way, whether it's through deciding it on the merits or some other way, and let this issue be resolved other than through a judicial decision forbidding the democratic process to produce what it produced. That is a critical question. You could say, again, that is, I think I'm repeating myself over and over again, that's the question the court has been grappling with as a matter of its role since really the collapse of the New Deal period and the 1937 settlement, right? And when the Lochner era collapsed. The court has been grappling with, you see it in Caroline Craddock's footnote 4, you see it elsewhere, you see it in Griswold and Rowe and Casey, and all these places where the court is talking about what are we supposed to do, what exactly is our role. This case puts it right in their face, I think, unlike any case that has occurred in the last 50 or 60 years, right? I mean, this isn't the Gun-Free School Zones Act. I mean, possessing a gun in a school zone was already illegal in all 50 states. So when the court struck that down in Lopez, it had absolutely no practical significance. None, right? This matters. It really, really matters. And so, are they gonna do it? Right? I mean, that's really the case. That's the thing they have to look in the mirror and decide, is that for us to do? So that's why I think this is just so incredible, that all of these things are kind of wrapped into one little package. It's sort of all of constitutional law in one little ball. So with that's why I'm interested. That's why I think it matters. Again, if they just sort of say, "Whoa, the Anti-Injunction Act means no one has jurisdiction here. We can all go home." Well, then maybe it ends up not mattering very much. But I don't think that's going to happen. And I think we'll look back on this moment in ways that we've looked back on things like West Coast Hotel versus Parrish, or Dred Scott, or McCulloch versus Maryland as being critical turning points in constitutional history. It really saying very saliently what the role of the Supreme Court is in our constitutional system. So that's all I really wanted to, because I've said so many things before, and I'll just leave it open for discussing anything you all want to talk about.
So I'll give you a chance to one-up the Attorney General. What is, in your opinion, the best argument for the limiting principle? If the government can do this, what can't they do in relation to using Commerce Clause powers? He basically flooded that argument before the Supreme Court, at least in the opinion of the commentators.
Don. Poor Don. Don he's a very, very, very good guy and a very good lawyer. He didn't have his best day, but I would defend him to some degree. I think it's a very difficult argument to make. Now, if you're asking me what argument would I make?
Yeah.
Okay. My argument, if I were making that argument on behalf of the United States government, is here's what I'd say. You have a industry and a market that is simply sui generis. It is simply unlike any other market in the following respect. We never know when we're going to need it, right? The vast majority of needs of health care for those, significant needs of health care for anyone under the age of 65 is a bolt out of the blue, completely unanticipated. Incredibly high cost, right? Again, for most Americans, a significant health event is going to bankrupt them, send them into personal bankruptcy. 3, we have an ethic, a moral norm in this country that when people can't afford health care, we're going to provide it anyway. Which means, unlike in other markets, like cars or housing or whatever, the failure to plan in advance financially produce externalities, and those costs are going to be shifted to everyone else in the market in the form of uncompensated care provided by the providers, and in the form, therefore, of increased premiums at a rate of about additional $1,000 per family that is covered by private insurance in the country, right? And taxpayers' dollars, right, through the uncompensated care that's provided by them. You put those things together, right? The externality problem, the cost shifting, the size of it, the inability to predict it. And that makes requiring individuals to purchase this particular thing, healthcare, distinct from requiring them to purchase anything else. There's really nothing like it. Now, is that a nice, clean, logical, black and white categorical distinction? No, right? So is it going to satisfy people who think in those terms, like a Justice Scalia? Absolutely not, right? People who think in bright lines are not going to like that sort of, well, if you add up all these different factors, it's really qualitatively different. It's going to be unsatisfactory. For people who have, brains that think a little differently and are comfortable with a little grayness around the edges, that's, I think, a satisfactory answer, because I don't think you can come up with any industry that lines up on all of those things. Yeah, Adam.
Sort of continuing focus on our dear friend Mr. Scalia. In his concurrence in Reich, there is some language which would seem to indicate that if it's part of some larger regulatory scheme, in that case the Controlled Substances Act, in Reich, that Congress can start to sort of reach out into inactivity if it begins to undermine.
Whoa. Does he use the term inactivity anywhere in that?
I'm trying to remember, because I think he comes darn spitting distance close.
By using the term activity.
But I think there's a word in there. There may be,
47 uses of the word activity zero uses
Zero
is the
uses,
word inactivity.
Yeah.
Now, if you take the spirit of that concurrence, I agree wholeheartely. Now, what Adam is referring to is in Raich versus Gonzalez, the case involving angel rage and medical marijuana, and whether the Controlled Substances Act could reach individuals, right? Controlled Substances Act prohibits, among other things, mere possession of marijuana. The question was, can the Commerce Power accommodate that when someone is merely growing marijuana intra-state, nothing crossing any state boundaries, and no commerce involved, right? There's no commerce. It's merely possession for personal medicinal use. Scalia writes a separate concurrence where he says, look, once Congress has enacted a broad regulatory scheme, it's entitled to regulate any conduct that's necessary to ensure, necessary and proper, I should say, to ensure that, right, that regulatory scheme is effective, right? That's the whole lesson of Raich, right? And I think he says it more articulately than Stevens does in the majority opinion, but it's really the flavor of both opinions, right? And you say, well, doesn't that apply here? Okay. Again, in Scalia's defense, let me argue back issue. One, Scalia says activity, right? So he can very easily say, sure, but what I said was Congress can regulate whatever activity is necessary to regulate in order to make that that broader regulatory scheme effective. That's fundamentally different than just conscripting people who are doing nothing but sitting on their living room couch, right, and forcing them to do something. At least Angel Raich took the affirmative step, the voluntary step of growing marijuana, knowing full well that possession of marijuana was a controlled substance, okay? Second point would be necessary and proper, right? Necessary and proper. And what Scalia, I think, would say, he says this in oral argument about, I don't know, 25 minutes into Verrilli's presentation, he says, if we know one thing from Raich and Morrison and Lopez, and really from our history, it's that the federal government's powers are limited, right? They have to be limited. They're not, otherwise the federal government has a police power and the whole thing doesn't make any sense anymore. Federalism no longer exists at that point. So we know the federal government's powers have to be limited. Any interpretation of the commerce power that lacks a limit is no longer proper. And he was basically saying, I think, I could kind of hear him reasoning through, and this was argued by Ilya Sonin in his amicus brief on behalf of, I think it was the Washington Legal Foundation. If you interpret the commerce power to be so broad, even if it fits within the doctrinal framework he set up in Raich, well, then there's no longer a limit, and if there's no longer a limit under that interpretation, it's no longer necessary and proper. So that would be the argument back.
So he would say, well, sure, it may be necessary. I can concede it's necessary.
I think
Death spiral, that's bad.
Right.
But it isn't proper. It's improper. It's kind of vulgar.
I think if you got Paul Clement and sat him down and asked him, Paul Clement, who has argued this on the behalf of the state, I think he'd say it's necessary. I mean, I've talked to Randy Barnett, who wrote the brief on behalf of the private plaintiffs. And Randy Barnett says, oh yeah, it's necessary. It's just not proper, right? It's necessary in the sense that the McCulloch versus Maryland sense that it is directly related to, right, the goals of the broader regulatory scheme. But then he would say, but you can't accept that, because if you accept that, then we no longer have any limit on Congress's enumerated powers, and we know that result cannot be right. Yeah, Eric.
So in the months kind of preceding the enactment of the PPACA, the Obama administration was kind of out there in the media saying this is an exercise of our commerce powers, it's a penalty. The penalty, it's not a tax, it's a penalty. They've repeated that many times. Mm-hmm. And one of the issues is, and after oral arguments, it came out, if they had just said that this was a tax from the beginning, we would have been saved this entire mess. There's no way they could have struck it down if they, used it on that basis, the tax powers. So what's your take on that? Would it be valid as a tax, and would that have saved us this trouble?
Yes and no. I'll take the no part first. I think if they had just said politically, this is a tax, and they had changed some words in the document just to say, we are hereby deeming this to be a tax, that wouldn't have made any difference. Could you have restructured the statute itself to actually make it work more like a tax in practical effect? Yes. And would that have avoided all of this mess? My answer to that is maybe. And I mean, sure, they're willing to say now, oh yeah, we would concede that that's perfectly constitutional. But if that's the one that had actually passed, I'm not so sure those same people would say, oh yeah, it's perfectly constitutional, right? I mean, the first talk I gave on this, that addressed these topics was when, at that time, actually, in the fall of 2009, I talked about like constitutional issues that were upcoming and stuff. And at that point, while the bill was being debated, both in the House and the Senate, you know, the president, I think it was in September, had gone to the joint session of Congress to kind of reinvigorate the push. And that's when he got called, I think it was when he got called a liar by someone in the House. So you might remember during that time, that was when people started saying, right, because it had the individual mandate in it, that might be unconstitutional. And that was the birth of this question that has evolved into a huge Supreme Court case. 2 years before that, though, I mean, no one, even though there were lots of proposals floating around that included an individual mandate, whether they be in the state of Massachusetts, whether they be in white papers actually written by the Heritage Foundation, of all places, there were all sorts of people that were proposing individual mandates to solve the market problems within the healthcare markets, and no one was asking whether Congress had that authority. It was only once you had this incredible mix of policy, politics, partisan positioning, and legislation and running for subsequent elections that the whole thing came into, kind of crystallized into an issue to have a huge constitutional debate about. So I would say maybe everyone would have just said, okay, yeah, I guess it is plainly constitutional, we can all go home. But I tend to think what happens is that the system is more dynamic than that. And that what is or is not a colorable argument about constitutionality shifts based on political incentives. And so you kind of have, you always have, and this is not meant to accuse Republicans or conservatives because Democrats have done the same thing. The goalposts are constantly moving. And therefore, I'm not sure that we would have been, I think the administration would have been in a stronger place if they had written it a little differently. But that, I don't think it would have completely ended the whole thing.
Do we have analogous taxes of non-activity?
Analogous taxes of non-activity. Analogous is kind of loaded in this context, right? I mean, is your tax burden greater if you fail to purchase your house instead with a loan rather than renting it, or rather than purchasing it all with equity, right, with cash? Yes, right. The inaction of not taking out a mortgage-backed loan results in a higher income tax burden to you. There are literally thousands of similar instances. Now, some people would say that's not really analogous, but that kind of punts us back to the question of whether this is really a penalty imposed on nonfeasance, or instead is it adjusting your tax burden based on whether you do or don't do something else. It doesn't end up solving the problem, it just moves it to a different place. Yeah.
So constantly politicians are weighing in on whether they think it's constitutional or not, but rarely do you ever actually see a constitutional argument debated by a politician, and if you do, it's so watered down that it ends up being criticized, like what happened with Obama with the Lochner comment. I mean, why do you think, I almost feel like I know the answer to this, but why do you think that politicians are so reluctant to actually have a conversation about the constitutionality with it when you compare it to during the Lochner era when FDR was having all these challenges? He had, like, I think an hour and a half just open conversation, no speech, just opening and talking about the constitutionality of these different bills that were getting knocked down.
Yeah, I think a lot of things are beyond my competence. That feels really beyond my competence to offer a great answer to. I think part of it is that our attention span as a polity is not great. I think people ultimately are motivated by the policy results more than they are about constitutionality. I mean, this has been framed as a question of federalism, right? As what is in the national government's power versus what's in the state's power. But goodness gracious, they talk about unprincipled adoption of federalism and non-federalism. Just in the last 15 years, you see everyone just flipping sides all the time on federalism. If it's gay marriage and the Defense of Marriage Act, everyone jumps to one side. If it's healthcare, then whoop, let's musical chairs, everyone jumps over to the other, right? And so that's not, I shouldn't say everyone. Everyone meaning 85 to 90% of people. They're just
the term, constitutional is such a big topic now. Ron Paul kind of revitalized that, and it's just frustrating that nobody actually calls anybody out for saying that they're making a debate, but they're actually not making a debate about the constitutionality of something.
Right. Now, and that raises what I think is a really interesting constitutional question that gets at the last sort of point that I raised as to why this is so interesting. Some people will say that the Supreme Court's willingness to decide so many constitutional issues as a matter of constitutional law, right, to make them questions for the court to resolve, has created a sort of judicial overhang that has relieved our political process of having to engage in serious political constitutional conversation. Because they know, whatever they do, ultimately, on the constitutional question, doesn't matter. The Supreme Court's going to take care of it for them, right? So you could say one of the real downsides to our modern system that has placed so much emphasis on the Supreme Court's role in deciding major issues of public policy, whether it's healthcare or affirmative action or rights to abortion, or you name it. I mean, some of the major issues, gay marriage, the major issues of our day, what's resolved in the political process has much less significance than it once did. You go back to, it's fascinating. I was reading that Robert Caro has his latest installment of the LBJ biography coming out May 1st. If you go back to the last one, Master of the Senate, and read about what went on in the Senate of the United States in the 1830s when Henry Clay and John Calhoun were debating matters. That's where the real constitutional questions of the day were debated, not in the Supreme Court. I mean, there was occasionally in a McCulloch or something like that, but for the most part, the Senate was having real serious constitutional deliberation. So you have to kind of ask, well, what happened? Why did that change? And maybe part of the story is that the Supreme Court has sucked the oxygen to some degree out of that, right? Yeah?
No, I just want to make the comment. I think it's because a lot of our Congress people are not familiar enough with the Constitution to adequately discuss it.
That may well be true as well. But why are we electing members of Congress who are adequately versed in the Constitution, right? Because we don't value it quite as much. And why don't we value it as much? Because we expect maybe the Supreme Court to deal with it, right? I mean, it's hard to know where the causation lies in that whole dynamic. Yeah?
So I want to spin things out 10 years, maybe 50 years, on the assumption that the law is struck down, and ask what impact you might think that it would have on how the court is perceived and on the Constitution generally.
Okay, so I think, I've written this. I think the court is in a bit of a precarious place right now. Just a little bit of a precarious place. It's certainly manageable, but they have, Bush versus Gore is not a too distant memory, at least for some of us. Citizens United was only a couple years ago. They've got this case, And they've got a boatload of really divisive issues that are going to be there in the next 3 terms, right? They've got the Arizona immigration case that's going to be argued Wednesday of next week. And then in the fall, they're going to have affirmative action up again from Texas, which they well could basically say affirmative action's over in this country. They've got the constitutionality of the Voting Rights Act, at least Section 5 of the Voting Rights Act, which I said was the most significant federal statute until the ACA. They've got, what am I forgetting? They've got a sequel to Citizens United that's coming up. They have a whole bunch of really, I mean, Prop 8, I forgot, DOMA. They've got some really, really big ones. And if they go 5-4 on pure partisan alignment, right? And I don't mean to blame one side or the other, but if the 9 of them can't figure out a way of not looking incredibly partisan, I think it runs the risk of doing incredible long-term damage to the institution. Now, the institution has done a lot of real long-term damage to itself in history, and it's always survived. Now, Dred Scott, 1857, by 1875, it's kind of back to doing okay, right? It's 20 years. You had the New Deal crisis, and by, I don't know, 1950 or so, up until, at least by 1954, it feels strong enough as an institution to decide Brown, and it's 17 years. But, history's always contingent. It's hard to know. What if common law professors for the next, I mean, not to put too much, we're that significant, but you think about the lawyers going out there who don't have faith, right? I mean, if you have a generation of lawyers being educated by people who have lost faith in the institution, that is going to inform what lawyers going out into practice think and what they say just in casual conversation about the court for a long time. And those things are not easily undone. And that's true, and let me say, I just want to emphasize, because I got, roughly 1,000 emails from wonderful, adoring readers around the country. That is true, whether the 5 and the 4 are completely earnest and sincere in their views about what the Constitution means or not. The optics of 5-4 partisan split on all sorts of partisan issues creates the problem, no matter what's actually going on in their heads. So I think that's a huge, for people who care about the court as an institution and care about its role in our system and think it's really important, then I think there's reason to be concerned about what they're kind of hurtling towards. And part of it is it's a collective action problem within the institution, right? Roberts is the lead, he's the chief, but he can't, I mean, I've seen what chiefs can do, and it's almost nothing. I mean, they can't, other than their own vote, they don't really have any leverage whatsoever. It's sort of like being a dean of a law school, right? You can say all you want to your faculty, man, but if they've got tenure, they can pretty much... Yeah.
So I have to ask, which way do you think Kennedy is going to go on this? I mean, he does seem to be the swing vote. It seemed that way 2 years ago, and here we are today, and it still seems that way.
Yeah, going into argument, I thought the chief, for kind of some of these reasons that we talked about, I thought it was conceivable that Roberts would say, I thought Roberts might do the following, and I don't mean to sound too cynical, but I thought Roberts might see all of these things coming down the pike, see issues that he actually in his heart cares more about, see that he'd rather those go a particular way, and say, this one, look, we're going to have a presidential election anyway, this thing could be gone without us taking it down, why don't I appear magnanimous, vote for it, it looks nonpartisan, all of that stuff, the act probably is not going to get fully implemented anyway, and then I get all sorts of sort of free reign to do all these other things that actually, in my heart of hearts, are much more important. But boy, oral arguments sure didn't look that way. Roberts seemed incredibly hostile to the government's position. Now, appearances can be deceiving, right? Who knows? None of us really know. So Kennedy seemed like the one, at least from questioning, who seemed to be wavering. But I think if you go through that transcript and you sort of think carefully about all of the things he asked, he certainly was expressing more skepticism of the government's position than he was of the state's or the challenger's position. And so, I mean, if I had to guess, I'm guessing he's leaning in that direction. I mean, going on whatever information we have. And they're not that cagey, in terms of shielding. I mean, one of the reasons they're not that cagey is because oral argument is actually the time in which they're talking to each other. There is a very strong norm in the institution that they do not talk to one another before oral argument about a case. So that is the first time that they are exposing to each other what they actually think about that case. Now, it wouldn't be too hard to figure out what some of them would be thinking about that case in advance, but they actually hadn't articulated that to each other. And that's why, to some degree, they don't use it to look as cagey as they might otherwise, right? To sort of guard the public from guessing what their votes are going to be. So my guess is, on your question, that Kennedy might guess, I mean, emphasize yes, is that he's going to vote to invalidate. But stranger things certainly have happened. Yeah.
Judging from your inside experience clerking, how important do you think the makeup of the clerks is? And back when you were clerking, did you get the feeling that clerks were hired on political lines?
So on the first question, 0. I think clerks don't matter at all. In a case of this magnitude, certainly. And I would say in general, the clerks don't affect results in cases at all. They might affect whether an infinitive gets split or not. But, in terms of ideology, it varies a little bit. And I think one of the troubling things, this kind of goes back to Michelle's question, I think. One of the somewhat troubling things is that the court over the last 10 to 15 years has settled into a pattern of the justices hiring more ideologically homogenous chambers. That Thomas's clerks are all, frankly, very conservative. Scalia's clerks for the last few years, he used to hire a token liberal. He really enjoys the exchange, but I think he's gone more to sort of homogenously conservative as well. I certainly get the sense that it's been the same with respect to Stevens and Kagan and Ginsburg. Breyer, I was in O'Connor's chambers, and our chambers sort of reflected her, which was kind of all over the place. So that was in itself somewhat representative. So yeah, I think there is a pretty strong connection. But in the middle, right, there's a connection in the sense that you have both. The year I clerked, there were both some fairly liberal and some fairly conservative clerks who were clerking for Justice Kennedy. So, yeah.
How do you feel about Elena Kagan not recusing herself after having been the Solicitor General during this whole legislative process?
Yeah, I am not an expert by any means on judicial ethics or ethics. So I'm not a great person to speak to it. I would just say that many justices in similar circumstances have not recused themselves. Right? Where you were in the Solicitor General's office when a matter was being debated within the administration, but you were not actually involved in that matter in any way, didn't take any official involvement in shaping the litigation strategy or drafting brief or anything like that. Those emails that she had with Neil Katyal showed that she had an inkling she might be picked, right, and had an inkling that this might be headed to the Supreme Court. And so whenever that issue came up, she very deliberately said, Neil, you are the one who should go to this meeting. I am not going to be a part of it. Now, whether that standard is appropriate or not, I think is a question better aimed at someone who knows more about judicial ethics. But certainly, I would just say if it's okay for Justice Scalia to go duck hunting with the Vice President when the Vice President has a case pending in court, this is not. It doesn't seem any more significant a breach of duty of loyalty. Yeah.
I was just wondering what your opinion was on the severability of the individual mandate.
Yeah, that's a terrific question. I'd say severability is actually. So just to mention this issue, so the Affordable Care Act itself is 2,700 pages, and the individual mandate takes up, in all of its provisions, takes up about 3.5 pages. The question is, if that is unconstitutional, is the entire act unconstitutional? And the entire act covers an enormous array of stuff. Severability is, the inquiry is kind of along these lines. If the court declares a part of it unconstitutional, would the Congress, that it enacted the statute, would it rather the entire statute go down, or would it instead have wanted everything else to remain in place? That's kind of the nature of the inquiry. But there are important shades in that, right? That one of the things that became very interesting is that as the court dug deeper into it, you see that the court said all sorts of things, many of which contradict each other. One is, imagine this inquiry, would the statute have actually passed? Right? The answer to that has to be no, right? Because the individual mandate was critical to sort of getting the legislative coalition together that would have voted, right? The same was true of whatever happened with respect to Louisiana and Nebraska, right? The Cornhusker kickback and the Louisiana Purchase or whatever those things were, right? To get Ben Nelson's vote and Mary Landrieu's vote, the thing wouldn't have been enacted but for those. But does that mean that they're inseparable? That's kind of odd, right? Just because you needed to include a little package. Let's say it was an appropriation for a dam in southern Louisiana. Does that mean the entire Affordable Care Act goes down? That would be really odd, right? So another way of thinking about it is, does the statute work? Well, that ends up being, or does it work in the way Congress envisioned? That ends up being an incredibly subjective inquiry. What do you mean by work? Does it work as well? Certainly not. Does it work decently? There are 1,000 different opinions on that, right? As to whether it can actually function reasonably well without the individual mandate. So it's a mess of a question because the law is just a total mess. Part of the problem that they're confronting too is a lot of it's already been implemented, right? Every day. Part of what the ACA did was include a bunch of appropriations that increased the Medicare reimbursement rates. So every single day, thousands of times over, anytime anyone files a claim under Medicare, they're getting the provider, the doctor, or the hospital is getting paid at a certain rate due to the Affordable Care Act. Well, is all that unconstitutional? Right? And does that mean that the day the opinion comes down that every hospital in the country has to go into the code of its billing system and change the reimbursement rate immediately? It's a mess. I thought they would be instinctively hostile to the argument that it's inseparable, and I just thought they'd see all these practical problems and say, look, this is a huge deal. If we're going to take it down, we're going to try to take down as little as possible. But the questions at argument made them seem much more open to taking down the whole act. One of the reasons they might be more inclined to take down the whole act is then they don't have to deal with the Medicaid question on its own, the spending power question, because if the whole act comes down, then they never even have to get to the breadth of the spending power. So, I don't know. Or alternatively, what some people have speculated is the severability question is such a mess, why don't we just uphold the mandate? Then we don't have to deal with it. So I think it's a total mess, and I had no idea what they're thinking. I had no sense where they were going after oral argument on that. Yeah.
Directly following up on that, is there a historical precedent for the Supreme Court striking down a key provision of the law, or the heart of it, if you will, and the rest of the law still sort of surviving?
Oh, sure. Yeah, lots. In fact, that is, you could say that's the historical practice. The most recent example was Sarbanes-Oxley, where there was a provision having to do with the appointment of the PCAOB, the Public Company Accounting Oversight Board. And the court held that that violated Article 2, that it was too attenuated the president's control over them because they had it was nested for-cause removal limitations. They can only be removed by the SEC. For cause, SEC commissioners can only be removed by the president for cause. Therefore, the president's capacity to control the PCAOB was too attenuated. Supreme Court just struck down that one little provision, the provision for how they get removed from office, and it left the entirety of Sarbanes-Oxley intact. Same was true in Buckley versus Vallejo for the major campaign finance reform that was enacted in the wake of Watergate, where they struck down a few provisions and left the rest of the act standing. That has been the historic norm. I think it's been since 1936, Carter-Cole, where the court took down the bituminous coal act, where it found one provision of a major federal statute unconstitutional, and then used that as a basis for taking down the entire act.
Following up on that, do you believe that is what the court might do in this case?
I think it's conceivable, but I just think it's, I thought they were all over the place at oral argument. I didn't have a very good read. I went into oral argument thinking, no way. No way they would do that. And then, you know, as usual, when I say no way that would happen, that's often. Okay, I probably have time for one more.
Okay. It seemed like during oral argument, I think on the individual mandate, the government was saying something to the effect of, we have a system where we obligate ourselves to, I guess, care for the other person. I was hearing kind of the soundbite.
Yeah.
And I thought Justice Scalia said, well, don't obligate yourself.
Yeah.
And I was just wondering if he basically just meant let people die, or if he meant...
Sort of. I mean, I think, again, to be charitable, I think it was kind of a tongue-in-cheek comment, but I think what he was saying is...
I'm sorry, dead people, it's just so funny.
I think what he was saying was this. It's kind of passing strange for the federal government to enact one law that obligates itself to do something, and then use that as a justification for expanding its power elsewhere, because they've tied their hands in another place, right? So I think he was perhaps inartfully trying to make the point that, look, when we're talking about the breadth of Congress's powers, it can't create a bunch of obligations on itself, which then it can turn around and use as justifications for expanding its regulatory authority, right? Now, the comeback to that is the mandate, those sorts of mandates, exist under federal law under EMTALA, which is a Medicare spending condition. But it doesn't just exist under federal law. Most states obligate, under state law, have similar conditions. We have one, under all of our counties are responsible for providing indigent care to people who need it. So it is a broader societal norm than the one that's codified in federal law. But I think that's the point that he was making. So we should probably get out of the room at this point and let Michelle have some lunch.